Appraisals are common when purchasing a home in Texas, particularly since they're almost always required by lenders when securing a loan. The Texas Real Estate Commission's third-party financing addendum, which is often added to the standard 1 to 4 family residential resale contract when the buyer is securing a loan, has a property approval section that allows the buyer to terminate the contract and get their earnest money back due to the home not appraising for the sale price under certain circumstances. This section of the addendum specifically says, if buyer's lender determines that the property does not satisfy lender's underwriting requirements for the loan, including but not limited to appraisal, insurability, and lender required repairs, buyer, not later than 3 days before the closing date, may terminate this contract by giving seller, number 1, notice of termination, and number 2, a copy of a written statement from the lender setting forth the reasons for lender's determination. If buyer terminates under this paragraph, the earnest money will be refunded to buyer. If buyer does not terminate under this paragraph, property approval is deemed to have been obtained. Now, I'm not an attorney, so please seek legal advice when interpreting contract language. But as you can see, the appraisal language is quite broad in this paragraph and allows for the lender to provide the buyer with an exit from the contract, along with their ability to get the earnest money back, without a requirement for much proof. All the buyer has to provide the seller is a letter from the lender stating the reason for the lender's unwillingness to provide financing. The lender could likely meet this requirement by stating the property failed to meet its underwriting requirements. As a result of the vague reasoning, this may leave the seller wondering what that means. So for a seller, they could theoretically negotiate to tighten up this language up front when negotiating the contract. But they'd have to get an attorney involved and would need to determine whether that might scare away their buyer depending on the market conditions and, of course, the market customs. Conversely, there could be a scenario where the lender provides property approval for the buyer, but the property doesn't appraise for the sales price. In that case, the buyer is likely putting more than 20% down and wouldn't have the right to terminate. So for this reason, a buyer should not just assume the appraisal language will protect them by allowing them to get out of the contract. If this is a concern, the buyer should ask their lender up front before making an offer. There are other options for greater protections for buyers and sellers. There is an appraisal addendum that can be added to the contract called the Addendum Concerning Right to Terminate Due to Lender's Appraisal. This addendum has 3 basic options. First is where the buyer waives their right to terminate based on the appraisal results altogether. Second, the buyer makes a partial waiver of their right to terminate due to the appraisal results. And third, the buyer is provided an additional right to terminate if the property doesn't appraise for at least a certain amount and conditioned on the buyer providing a copy of the appraisal to the seller. In deciding whether to use this addendum, the buyer and seller will need to consider whether the market conditions and market customs will allow them or necessitate them to negotiate these additional appraisal terms to the contract. For example, in a hot market, it's common to see buyers waive appraisals. And in a buyer's market, it may be more common for sellers to allow buyers more appraisal protections. To conclude, there's some protection for buyers and sellers in the property approval section of the third-party financing addendum, but it is limited. In my experience, many buyers and sellers stick with using the standard language in this addendum, so hopefully this gives you a better idea of what to expect.